Now, there is a discussion, of course, too, about along the same lines with the Aubrey case about whether or not Rittenhouse was instigating these events just by being there in the first place. Can you talk a little bit about that? I mean, obviously, there's a lot of people who don't agree with him going to Kenosha in the first place. Is there any sort of legal consideration with the fact that he was there ostensibly trying to protect businesses from rioting, in his sort of personal capacity? Does that play any role in the legal claims at hand?
Not really. And the reason for that is as long as he was there lawfully in the first place, his own motivations for being there and that kind of thing don't really matter. There was nothing illegal about him being there. There was nothing illegal. The court has ruled now about him having the rifle while he was there. So he was acting lawfully. Whether or not he should have, as a matter of public policy or morally or anything like that, that doesn't matter. He was there lawfully, and while he was there lawfully, he was attacked. You could say the same thing about somebody going to a party and drinking a lot or something like that, and being out of control in that regard. It's legal to do that, and so if you're under those circumstances and you get attacked, you can still defend yourself. So the fact that he was somewhere doing something that some people might think he shouldn't have been doing, it wasn't illegal. So he was entitled to be there if that's what he wanted to do.
Yeah. And to that point about him having the gun, right? He's 17 years old. Technically, he lives one state over. This was sort of made there's a lot of hay made about the fact that he crossed state lines, right? Even though I believe he lives very close to Kenosha, even though it's technically across state lines. But a lot of people thought this was a very important point. And, he's carrying a gun that he can't legally purchase himself. And he was obviously charged initially with a misdemeanor for possessing that gun. What are some of the legal implications there? I guess there's a number of things we could talk about. I think first, the dismissal of the charge. Can you explain that statute a little bit? Because it's certainly confusingly worded, which I think, if I understand correctly, played into why it was dismissed, why this charge was dismissed. But there's a prohibition against minors carrying guns in Wisconsin, but there's an exception about there's sort of an exception written into that statute about how it only applies to short-barreled rifles or potentially to somebody who doesn't have a hunting license, but it's sort of confusing. You understand the law there better than I do. So can you just talk a little bit about why that charge was dropped in your view and what that law is supposed to mean?
So, I mean, that particular statute is not so unusual compared to other statutes when they get written and then changed over time. So you start off with a law that says it's a crime for someone under 18 to possess a firearm, period. And then later you say, oh, well, but it's okay. We actually allow minors to go hunting with long guns. So it could have been worded better, probably. But basically, then the wording that was put into the exception is that the prohibition against possessing a firearm doesn't apply to, and they didn't call it long guns, but the description they used basically means long guns. So it would have been simpler just to say it's against the law for a person under 18 to possess a handgun and then leave it at that. But that's not the way the statute was worded. It says it's against the law for someone under 18 to possess a firearm. And then you read on down farther and it says, but this doesn't apply to a minor possessing a long gun. It's really awkward to say it that way, but the bottom line is he never should have been charged with that. It was, if you read the complete statute, it's pretty obvious. It doesn't apply to minors possessing long guns, period. So it shouldn't have been charged. I think multiple times motions were filed to dismiss it, and it was not dismissed until pretty late into the game. But that never really should have been a charge.
Okay, so you don't take the view that it requires the minor to have a valid hunting license in Wisconsin for that to apply?
No, it doesn't say that. And there are a couple of different doctrines that apply. Probably the most important is criminal statutes are construed strictly against the state and in favor of personal liberty. So if it's kind of awkwardly worded, or there's some debate about, well, this only applies if you're hunting, if that's not what the statute says, the state loses. That's just the way criminal statutes are interpreted. So I think maybe the purpose of the exception is so that minors can go hunting with shotguns and rifles, but that's not the way it's worded. It just says it doesn't apply to carrying or to possessing long guns. So you don't have to go any farther than that. That's what it says. The state loses.